So we've talked in personal injury cases of the need for expert testimony or expert witnesses to review the case, help to guide the attorney who's working on your behalf, and so forth. This is especially true in the construction situation where our clients are suing for injuries on construction sites. It can be fairly complicated, and an expert is really at base a teacher and will help to teach you, the attorney, and a jury, if it goes that far, in what to look for on a construction site. Who is in charge of being responsible for safety, at least who sits at the top of the pyramid in terms of having the ultimate obligation, and what kinds of things should the person who's in charge look for. So the expert helps, but let me add a cautionary tale to that. As the courts of Massachusetts have said, experts don't decide cases, juries do. So that just gives you a sense of the limitation as to what experts can do. But they will help your attorney in reviewing documents and reviewing a lot of fact-related things such as daily job reports, various emails, letters, safety meetings, agendas for various meetings among many of the varied parties who are on a construction site. The expert will also give you a sense of what is appropriate under standard industry practice, and the expert should be thoroughly familiar with the OSHA provisions. It's those provisions that really offer a gold mine. Now, there are limitations on what an expert can give an opinion on. The expert can't say that the OSHA provision was violated, but the expert can certainly testify to what the OSHA provision calls for and how it applied in this instance. So I wouldn't get too bogged down in this evidentiary prohibition on an ultimate opinion as to whether it was violated or not. OSHA has 4 different categories in terms of employers on a job site. The one that we want to emphasize is the controlling employer, who is really the general contractor who has supervisory authority on a construction job site. And there's a 2-step process that OSHA calls for in determining whether the employer is in fact a controlling employer, and that typically is the general contractor, and as to what efforts were made to comply with that duty. Things that they look at are the scale of the project, the nature of the work, and the safety history of the people involved on the job site. Was the particular subcontractor one who had a history of OSHA violations? If so, as you can imagine, the requisite level of supervision over that subcontractor should be higher. And I have often analogized or compared it to in terms of whether there should be safety attention if a particular subcontractor knows that a general contractor is not going to pay attention to safety, is rather lackadaisical, that subcontractor will be more apt to cut corners and not pay attention to safety. It's somewhat akin, this is the analogy I want to make, somewhat akin to a teacher leaving a room during a test. Children are more apt to cheat on the exam without appropriate supervision. And again, it's all about appropriate supervision. That's what we, as the injured workers representative, want to say. Thank you.